Well, good morning, everyone, and welcome to our next session in our ongoing adjudication training syllabus presented by CAASA. Just by way of introduction, my name is Vaughan Hutton from MDA Attorneys, and we today have together with us another guest speaker, Serena Jones from Serena Fourie Incorporated. And Serena and I are going to be looking today at adjudicators' fees and costs in the adjudication. Serena, just by way of introduction, obtained an LLB from University of the Free State in 2002, was admitted with right of appearance to the High Court in July of 2003. Obtained an LLM cum laude in civil procedure and private law in 2004 from the University of the Free State, and has practiced in personal injury law and medical negligence claims until 2010. Also was a part-time lecturer at University of Pretoria in private law, and that was in 2008 and 9. And then Serena moved from that, specializing in a highly specialized field of legal costs and cost consulting, which she's been involved in since 2010. This involves drawing bills of costs in litigation and arbitration matters, attending taxations, assessing bills of costs, and advising on cost-related matters in all the courts across South Africa. And she's a specialist cost practitioner in the Supreme Court of Appeal and a member of the panel of cost consultants for the Free State Division of the Legal Practices Council. And Serena is going to be looking today at the issue of costs, both in terms of general principle and also in terms of assessing costs and the requirements that not only persist in our courts, but pertain to any person with authority, with jurisdiction, to determine costs and the responsibility for costs, which becomes a liability of either a claimant in an arbitration, a applicant or claimant in a litigation. And as we know, in certain instances, in adjudications, the adjudicator acquires an obligation and a jurisdiction to also decide on a liability for costs. So we're going to move in from a discussion that I'm going to be doing quickly now, dealing with the issue of adjudicators' fees, and then moving into an introduction of the idea of costs and the applicability of costs awards in adjudication. Because in certain circumstances, an adjudicator does have authority to decide and determine a liability on either or one or the other parties, and proportion a responsibility for costs. We can also be looking at the type of costs that one would generally look to recover in an adjudication, and also generally. Thank you very much, Serena, for joining us. And I'm sure we're going to have an interesting discussion this morning. Please, if everyone and anybody wishes at any time to raise a question, ask a question, one can either do it, I'm sure, with the hand up signal, or sending through questions to our administrator, Tiffany. So without further ado, let me move on. And in my discussion, I just want to look at an area that has been not within our South African courts, not that hotly contested, but yet is an area that I'm finding is becoming and has been topical over many years, and that's the question of adjudicators' fees. Now, in our ad hoc adjudication environment, where, as you're all aware, we are adjudicators acquire a jurisdiction by contract and by agreement between the parties, and we have a so-called system of ad hoc adjudication or contractually seated adjudication. The relationship between the parties and the adjudicator is regulated by contract And within the contract and within the regulations that, that one agrees to in the adjudication, one of the things that are agreed is the liability or responsibility of the parties to make payment of the adjudicator's fees. And generally, the adjudicator's contract themselves, or the rules incorporated into and by the adjudicator's contract, generally require two things and obligate the parties to be jointly and severally liable for the adjudicator's costs, or typically to be responsible and make payment of the adjudicator's costs in equal shares. Now, these, as I say, we don't have much case law regarding adjudicators' costs and adjudicators' fees, specifically in South Africa. But in the United Kingdom, particularly pre-enactment and coming into effect of the Housing Grants Regeneration Act, a number of cases have dealt with this question, and also in instances where the adjudications have taken place either before or during the period prior to application of that legislation, costs and the responsibility for payment of adjudicators' fees has been and was regulated largely by contract until the enactment of Section 108A of the Housing Grants Regeneration Act, which deals specifically with obligations in respect of the adjudicator's fees. So the leading decision on, and English decision on this question of adjudicators' fees was given by Mr. Justice Vivian Ramsey in a leading case of Lynette versus Halliwells, LLP. And it's a 2003 decision in which Mr. Vivian Ramsey looked at and considered the issue of adjudicators' fees, entitlement to be paid, among other questions. So the first starting point in respect of an entitlement to be paid fees in terms of that decision was that the right to payment of fees to the adjudicator was not affected by the terms of the decision that was given, but determined rather between the parties themselves as to who was to bear the costs in the adjudication, the fees of the adjudicator rather in the adjudication. So there was no effect on the adjudicator's contractual entitlement or right to payment. And what Vivian Ramsey did was he then split up the consideration as to when an adjudicator would be entitled to be paid by looking at a fundamental question which we dealt with during our last seminar, and that is the question of jurisdictional challenge. And what Vivian Ramsey did in this case was look at the adjudicator's entitlement, which he found was an entitlement afforded and created through contract, and asked the question as to when the adjudicator would be entitled, particularly where there is a jurisdictional challenge to the adjudicator's jurisdiction to determine the disputes, and on the other hand, when there is no jurisdictional challenge. And the easy question, I guess, is the position where there is no jurisdictional challenge. And at the important point where there is no jurisdictional challenge, Judge Ramsey concluded as follows. Where one party agreed the adjudicator's terms, but the other did not, then the adjudicator could enforce those terms against the party with whom he has a contract. If an adjudicator was appointed and neither party made a contract with the adjudicator, then both parties, by participating in the adjudication and thereby requiring the adjudicator to act, entered into a contract with the adjudicator, who acted in that capacity as a result of that request. A contract would be formed by conduct, and there would be an implied term that the parties would be jointly and severally held liable to pay his reasonable fees and expenses. he moved on and stated, in principle, the same situation would apply where one party made a contract with the adjudicator, but the other did not. The party who had not made an express contract, but who participated in the adjudication, thereby requested the adjudicator to act, such that there was a contract made by conduct between the party and the adjudicator. The same terms as to the reasonable remuneration would therefore be implied. So in respect of or in instances where there is no jurisdictional challenge, the situation or the entitlement, I think, is quite clear. And what Judge Ramsey has done in that instance, he has particularized the situation where, in the absence of an express agreement, but yet a nomination to act and a willingness to act, the parties would then be obliged to make payment of the adjudicator's fees and a reasonable remuneration. Typically, in our context, one agrees the fees, one agrees the adjudicator's terms, and one incorporates those terms specifically into the adjudicator's contract, which then is signed as a tripartite agreement. However, notwithstanding that signature in the presence of a written contract obliging the parties to make payment to the adjudicator, in the instance where there is a jurisdictional challenge, one has to take a bit more of a careful look. And during our last discussion, we looked quite in detail to the issue of jurisdiction, and we highlighted the importance of adjudicators dealing with jurisdiction. And the entitlement to be paid one's fees is also something which necessarily follows the question of whether there is jurisdiction to deal with the dispute, what that jurisdiction is, what the extent of it is, and whether or not the adjudicator has complied and fulfilled the jurisdictional entitlement that the adjudicator has. Now, in respect of the situation where an adjudicator's jurisdiction is challenged, Ramsey dealt with this in a fair amount of detail again in the Linnet decision. And in that decision, looking at the question of jurisdiction, what he held was, what his position was clearly set out and determined against, I think, what is typically a position that one looks at in dealing with jurisdiction, and one that we dealt with in some detail during our last seminar. But just to clarify the point and to drive it home, Ramsey dealt with the contractual position between the parties and the adjudicator where there was a jurisdictional challenge, saying that a party who wished to raise a jurisdictional challenge had two options. You'll recall we dealt with this in some detail during our last discussion. First, it could make an assertion of lack of jurisdiction and withdraw, taking no further part in the adjudication proceedings. In those circumstances, in the absence of an agreement with the adjudicator, there would be no request for the adjudicator to do anything, and it would be very difficult to make that party liable for the fees and expenses of the adjudicator. Second, the party with the jurisdictional challenge could use the challenge and then, could raise the challenge and then continue to participate in the proceedings. And this by far is a typical position that we have in South Africa. Also in instances where a party admits the jurisdiction, then obviously this consideration doesn't apply. By participating in the proceedings, Ramsey held, the party was not giving the adjudicator jurisdiction in making a binding decision, because there's a reservation of the right to challenge and a participation in the adjudication on the express understanding that the adjudication, the challenge to jurisdiction, is pending. So the party then was seeking a decision on jurisdiction that might provide it with a benefit. So irrespective of the reservation of the right to challenge the adjudication, the party that is participating is still requiring from the adjudicator a decision that may or may not be to that party's benefit directly. So in principle, then Ramsey went on and held that by participating and requesting the adjudicator to adjudicate on the dispute, that party will generally be liable for the reasonable fees and expenses of the adjudicator. The fact that a party makes a jurisdictional challenge should not itself affect its liability to pay the adjudicator's fees if that party participated in the proceedings. Then on the facts particular to the Linnet decision, he found that the adjudicator proceeded in compliance with the requests from both sides. So both sides were jointly and severally liable to pay his fees. Although he did conclude that on the facts, the adjudicator did not have the necessary jurisdiction, he found that because of their active participation in the adjudication, Halliwells were liable for his fees, even if the adjudicator had not had jurisdiction. So the question then of a jurisdictional challenge and dealing with that jurisdictional challenge is extremely relevant to your entitlement to be paid your fees at the end of the day, even though there is that contractual obligation that one takes on. So where a jurisdictional challenge succeeds, and it's found that an adjudicator continued on fault or misconduct in failing to appropriately apply the principles of natural justice, for example. This has been dealt with as well in the English courts in a case of Paul Jensen Limited versus Staveley Industries PLC. Again, a 2001 decision by Mr. Justice Donnelly, where it was held that where an adjudicator in good faith continues and later becomes aware or is found not to have jurisdiction, then the adjudicator may still be entitled to payment of its fees, depending on the extent of the dispute that was decided in relation to his jurisdiction. An important decision that preceded the Paul Jensen decision was in the case of Griffin and Avor, trading as K&D Traders and versus Midas Homes Limited. That was a decision again in 2000 by Justice Lloyd QC, where he held that an adjudicator had jurisdiction to deliver part of his decision, and no question that in respect of that part, the adjudicator should recover his fees. So in respect of the part of the decision that the adjudicator found he had jurisdiction to deal with, there was no debate about the responsibility and the entitlement to be paid fees. In respect of that part of the decision that the adjudicator did not have jurisdiction to deal with and to decide, the adjudicator was in breach of contract, and the referring party who referred the dispute that it was not entitled to have referred was in breach of its contractual obligations, and therefore found that in that instance, the referring party would be responsible for the adjudicator's fees in respect of that portion of the dispute that the adjudicator did not have jurisdiction to deal with. And it highlights again the importance then of a decision on jurisdiction and dealing with jurisdiction, not only in terms of reaching an enforceable award, but also in relation to the entitlement to be paid the adjudicator's fees. A slightly different position prevailed in the Scottish courts in a case of Prentice Island Limited versus Castle Contracting Limited, where the court for different reasons found that an adjudicator had in good faith fallen into error and continued to act when he should have resigned. The court held that the fact that the adjudicator had remained in his post as a validly appointed adjudicator, conducted the adjudication in accordance with the procedures and in compliance with the rules of natural justice, but failed in, it was found that in a certain respects he did not have jurisdiction. The court there held that notwithstanding, the adjudicator was still entitled to be paid his fees. Now, this doesn't excuse a situation where the adjudicator, or rather support a position that the adjudicator is entitled to be paid fees regardless of conduct. That is not the case. And it's an important thing to bear in mind, because it goes beyond just complying with the rules of natural justice, but in terms of the adjudicator's conduct generally. And there have been a string of cases in the United Kingdom dealing with this point. I'm going to refer to a couple because I think they are pertinent, and this is something that does happen, and often allegations are made as to the conduct of an adjudicator, disentitling that adjudicator to be paid fees. Now, the courts in the UK, the TCC, considered this situation in a case of Dr. Peter Rankler versus Perco Engineering Services Limited and another. And this was a 2006 decision. And it was a decision that was given by Gilliand QC. So in this case, the court concluded that the decision was not in breach of natural justice. But he went on to observe, and this was also perhaps an obiter observation by the judge in that case, where he went on to observe that it was a surprising submission that if an adjudicator's decision had been reached in serious breach of the rules of natural justice, and thus would not be enforced by the court, that the adjudicator should nevertheless be entitled to claim payment for producing what is in fact a worthless decision without even temporary binding legal effect. This conclusion then was supported by Mr. Justice Robert Aikenhead in a decision of PC Harrington Contractors Limited versus Systec International Limited, which is a well-known decision. It was a 2012 decision by Aikenhead, where he took a similar approach. But very importantly, that approach was reversed on appeal. And in the appeal decision by Mr. Lord Justice Dyson, who at that stage was the Master of the Rolls in the UK, the appeal court decision was given in 2013. And very important extract from that judgment provides at paragraph 32. I return to the question, what was the bargain for performance? In my view, it was an enforceable decision. There is nothing in the contract to indicate that the parties agreed that they would pay for an unenforceable decision, or that they would pay for services performed by the adjudicator, which were preparatory to the making of an enforceable decision. The purpose of the appointment was to produce an enforceable decision, which for the time being would resolve the dispute. A decision which was unenforceable was of no value to the parties. So one must bear that in mind, and the position taken in the United Kingdom when producing and dealing with and eventually producing an enforceable or an award that should be enforceable. And obviously this is said subject to, and that decision was given subject to trite law, that an adjudicator may indeed make errors of fact and law. This decision and the principle goes more to the fact, or the issue rather, of when a decision is made and the adjudicator has done that incorrectly and contrary to the precepts of natural justice. And that goes to the adjudicator, not only the adjudicators themselves, but the conduct generally of the adjudication, the following of prescribed procedures, the implementation of agreed procedures, which is something that one has to always bear in mind when dealing with adjudications and moving through an adjudication as an adjudicator to provide an enforceable award. Now, part of that award that one gives as an adjudicator may include an award as to responsibility for payment of costs. Serena is going to take us through and explain in more detail what that means in South African terms, what we understand by costs, what are costs, how they are derived and determined, and the processes that are involved in getting to a point where those costs become fixed and are determined and become payable. Now, in terms of the adjudicator's award, there's generally one of two ways that an adjudicator can acquire a jurisdiction to make a costs order. And remember, without a jurisdictional entitlement to make an award as to costs, the adjudicator has no authority to make a costs order, in which case one reverts back to the question of liability for payment of fees and that which we've just finished discussing. So, in order for one as an adjudicator to determine and to make an award as to costs, there has to be jurisdiction. And this is given to an adjudicator in one of two ways. Firstly, it could be given as a matter of contract, and the parties agree contractually to the adjudicator having a jurisdiction to determine costs. One typically thinks of the JBCC rules, the 2021, I think it is, and other similar rules that expressly give the adjudicator that jurisdiction, in which case it's a contractual right, it's a contractual obligation, and there is without doubt a jurisdictional entitlement and indeed corresponding obligation on an adjudicator then to deal with the issue of costs. And as I'm sure Serena is going to highlight, it's not always a simple thing to deal with. All too often in proceedings, one deals with costs at the back end of things, and there's sometimes not enough attention given to the detail of what it is that you want to be paid, what it is that you believe you're entitled to be paid. And very often this is dealt with as a passing aspect of the case. And I have found in many matters where the cost consultant in Serena's position is left with a difficult task of convincing a taxing consultant, a taxing master in courts, or an independent third-party taxing consultant as to the entitlement of what should be paid. So, in the absence of there being a contractual right and a jurisdictional right then to determine costs, the English courts have also looked at this issue and considered where and what circumstances that jurisdictional right might accrue to an adjudicator. The leading case on this point is a case called of Northern Developments versus Jeff Nicol. It's a 2000 decision by Mr. Justice Bauscher, QC, and it's reported in the British law reports, the building law reports. Copies of all of these cases will be made available on the CAASA portal. The developments case, the court then found as a starting point that an adjudicator has no general obligation or general jurisdiction to determine costs, as we've just discussed, in the absence then of a contractual obligation to do so. That jurisdiction doesn't accrue as a general obligation. However, in that case, the court went on to find that the adjudicator had been granted jurisdiction to determine costs by an implied agreement. And this is a very important consideration, because I have matters where I act as adjudicator, and as a matter of course, the parties preparing papers add in a prayer for costs and include in that prayer then a costs entitlement and even present argument as to costs. The other party then responds with a similar request, and in the absence then of a contractual right, through that exchange, as in this Northern Development case, the adjudicator may very well then acquire a jurisdictional right to deal with the costs element of the disputes. Now, this jurisdictional right then comes about by an applied agreement. And in this Northern Development case, the implied agreement existed because both parties had requested payment of costs. Neither party had objected to the adjudicator's jurisdiction to deal with costs, and both parties were represented. In the one On the one case, in the one party was represented by an experienced claims consultancy, and the other party represented by a seasoned legal practitioner. In the presence of those three facts, the court therefore found that the adjudicator's jurisdiction had been enlarged to deal with costs. So the jurisdiction to deal with the dispute as a separate issue had been extended through this implied agreement via the exchanges. And you'll recall when we had that discussion on jurisdiction, one of the things that we looked at was the fact that through the adjudication process, one has the initial threshold jurisdiction, and that threshold jurisdiction needs to be maintained and can also be extended. So in the notice that one acquired, the notice of dispute initially, there may not be a request for costs. But as in this Northern Development case, through the exchanges of information and the respective referral and response, the parties requested expressly that payment, that costs, that the adjudicator deal with the issue and find a liability and responsibility on one party or the other. This reasoning was followed subsequently by Mr. Justice Marshall Evans QC in a case of John Cathliff and Alan Build Northwest Limited. In that decision, the court took, as I say, a similar reasoning and found this in the same circumstances that the adjudicator had an extended jurisdiction. So both cases illustrate the dangers of one party expressly seeking their costs in the adjudication. If they do so, there is at least the risk that this will begin a process that will ultimately allow the adjudicator to decide, in an appropriate case, say where all the claims have failed, to award costs against the referring party, or where all or most of the claims have been successful, to award costs against the responding party. So the obligation then to deal with costs is not necessarily one that is prescribed at the outset. It may be through a contractual agreement. Alternatively, as we've seen with reference to these two cases, it can also arise through this implied agreement by conduct. Are there any questions that anyone would like to raise at this point before we hand over to Serena? Tiffany, I don't know whether you can see any questions. I don't see any here on my screen.
No, Vaughan, currently not. Nothing in the Q&A box. I don't know if anyone wants to raise their hand with a question. Okay, no,
Thank you.
I think we're good for now.
We'll obviously also, I'll be available at the end should anyone wish to raise any points or debate any issues. On that note then, thank you very much. I'd like then to hand over to Serena Jones to deal more comprehensively with the immediate question, and that is the costs issue. Thank you.
Thank you, Vaughan. So we've gotten to the point now where the adjudicator has made a cost order. It's always important at the onset to look at what the purpose of a cost order is. So a cost order is made to indemnify the successful party to any process for their legal expenses and work the costs of running the matter. Now, different types of cost orders will give you different levels of indemnification. The cost order will mostly follow the outcome of the matter. For example, if your referring party was successful, then the cost will probably be awarded to them. There are different considerations that need to be taken into account. A court or adjudicator can make an order that each party will pay its own costs, but usually the successful party will be entitled to recover their costs from the unsuccessful party. It's important to remember that it's only the fees and disbursements of the representatives of the client that can be recovered. Work done by the client himself will unfortunately not be covered by such a cost order that is made. So when we look at the different cost orders that can be made, the baseline cost order, which is usually the cost order that will be made by parties or an adjudicator or a judge or whoever is the presiding officer, would be a cost order on a party and party scale. So a party and party scale cost order will include all the fees and disbursements, attendances by the legal practitioners for work necessarily done to attain justice in the matter. This will exclude any unnecessary consultation. So basically you will look at what was the next step that needed to be taken and what was the reasonable work that I needed to do to get to that point. So that is everything that is absolutely basically necessary to proceed with the matter. Then you get a cost order on an attorney and client scale. There's also some disputes at this moment. The taxing master of the High Court has a discretion to deviate from the tariff. So the party and party costs, sorry, I forgot to mention that, will work strictly on a tariff that is prescribed. Usually in these types of matters, it will be the High Court tariff unless otherwise agreed or it's related to the quantum, but the high courts have concurrent jurisdiction with all the other courts. So usually you will get a cost order on the High Court scale, and therefore you will use the High Court tariff, which is prescribed by Rule 70 of the High Court rules. It sets out a whole set of attendances and specific fees that can be charged for those attendances. We'll get to that a little bit later on as well. So that's your party and party scale. On an attorney and client cost order, that is usually a bit of a punitive cost order. These special cost orders usually are. You will be able to recover your fees and disbursements. You will still use the tariffs as a guideline. The taxing masters in the High Court have a bit of a discretion to deviate from that if reasonable, but usually the tariff will apply still. But this will make provision for extra attendances that is not specifically included in the tariffs. For example, consultations which might not be regarded as absolutely necessary, traveling, accommodating your client in some sort of other way. Those will be, so that's work done by the attorney. That's not necessarily strictly necessary for the matter. The third type of cost order you can get is a cost order on an attorney and own client scale. That usually shows some sort of dissatisfaction with the unsuccessful party. On this scale, you will be able to recover your attorney's costs on the agreed tariff. Again, whoever taxes the bill at the end of the day still has a discretion to look at the mandate that you gave your attorney, the fee you agreed upon, and still decide whether it is reasonable. But that on that cost order, you will be able to recover costs that are a little bit higher than your normal tariff. So that will give you more indemnification than a party and party bill, and then or cost order. And then the last cost order that can be made is a cost order de bonus proprius, which is a cost order made against an attorney. This really shows a dissatisfaction with the conduct of the legal representative himself. That is a cost order that is not often made, and for processes of adjudication, that will have to be tested at the end of the day, whether the jurisdiction can go as far as to decide on the specific conduct of one of the parties, but we will have to see what happens when that happens. But that is not a cost order that is generally made. So on the onset, when you have legal representation, your attorney will sign a mandate or a fee agreement with you, and they should explain to you at that stage what the difference is between the different scales of cost that you can recover. You need to understand that even if you are successful in litigation or the adjudication process, there will probably be some costs that you still have to foot the bill for yourself. And that would be the difference between the attorney and client, or the attorney and own client fees, and the party and party fees. Your attorney's fees will probably be more than what is prescribed by the tariffs. So it's always good to be aware of that at the onset of taking or giving instructions to a legal representative, to make sure that you understand that even if you are successful, you are most probably not going to be able to recover all of your costs. Okay, so those are the general cost orders that can be made. Usually, as I said, party and party costs would be the normal cost order that will follow the process and will be awarded to the successful party. Now, the procedure, we'll get to the taxation procedure a little bit later on, but you will be drafting a bill of costs. We call it a bill of costs. It's an itemized bill. It's got certain requirements. It needs to be in date, chronology. You need to specify all the work done. You need to specify the time spent on the work, and then the prescribed fee that is charged for that service that was rendered. Most attorneys firms these days have specialized or draftsmen of bills of cost, or cost consultants, or attorneys specializing in bills of cost that draft these types of bills for them. All your items need to be numbered, and it's always good when drafting a bill or presenting a bill for taxation to let the bill read like a story, so that you can know when what the procedure was. It's very difficult if you just say, I made copies and I drafted that. It's always a good thing to say, consulted with client, received documents, I made copies for the council, I drew a brief for the council, then we went to the council and consulted, so that your bill makes sense, so that you can place what work was done at what stage. And then obviously at the end, you will total up your bill, your disbursements that was incurred during the process. This will include your counsel's fees, any experts, any traveling fees for authorized inspections in loco, etc., will be included in your bill. These disbursement vouchers or proof of disbursements should be attached to your bill at the end of the day, so that can be scrutinized by the opposing party as well. So that's basically the format of a bill of costs. So the cost that can be recovered in a process is prescribed by the High Court tariffs. They're pretty specific about what can be included and what can't be included, and there's a specific tariff attached to each of these attendances. For example, perusal of documents, there's a set charge per page, which is regarded as 250 words. So yeah, consultations are charged at a specific rate per 15 minutes or portion thereof. There's a specific charge for drafting of different documents, formal documents, and letters, telephone calls. Those things are all specified in the rules, and you stick to those tariffs. And then it is important to make use of somebody that knows what they're doing when drafting a bill. There's lots of money gets won or lost at the end of the day when it comes to taxation of bills of costs if you don't include everything that you could have included. So, for example, perusal of documents, you can peruse per page of 250 words, but there are still some discretions that the assessor or taxing master has with regards to that. For example, they won't allow a duplication of these. So if you working with contracts that have similar annexures or the exact same annexures, they will have a look at if there is a duplication of these. Did you really apply your legal mind while reading these documents? So there is a discretion of the taxing master. That the rule is basically always a reasonableness. What is reasonable under the circumstances, reasonable remuneration for the work actually done. Yeah, so the tariffs will be your baseline to look at to see what you can and cannot charge for. There are certain items or attendances that you have to have a specific court order for. So if your court order just says pay costs on a party scale, there are certain attendances or disbursements that you will not be able to recover unless the court order specifically provides for that. So this is important to realize when you're a party to the process. Also, if you are an adjudicator, to be aware of the fact that if your intention is to let the party recover these types of costs, you are going to have to specify certain costs. So the first one there would be inspections in loco. Inspections in loco can be recovered under normal party tariffs under certain circumstances, but it's always better to specify that in your court order, especially if it was a lengthy inspection or all the parties were involved therein, or there was any accommodation or traveling expenses involved in that. It's always good to, when you make your order, say, my order is party and party costs and including the following specified costs. So inspections in loco is always good to rather specify to avoid disputes about it at a later stage when the bill is presented for taxation. Experts' fees has to be specified, otherwise they will not be allowed. This and specified by name, so you'll have to say order for party and party costs, which will include the cost of the qualifying and preparation fees for the following experts. And they will have to be specifically named. You cannot recover the qualifying or preparation fees of an expert witness unless a court order or a cost order specifically makes provision for that. The qualifying and preparation fees for experts will include the gathering of information, the processing of the information, drafting reports, preparation for trials, and qualifying themselves to be a witness. So that's the first portion of expert fees, whatever it took for an expert to get himself to a position where he can give expert evidence on a matter. When an expert testifies at court, this is also an important thing to remember for all parties involved. If it's always good to specify or specifically ask for the witness fees of the expert witness as well, and agree the tariff on that. Otherwise, your expert will only be entitled to a normal witness fee, which is very little, so they won't be able to, you will have to, the attorney-client scale that is going to cost you a bit of money at the end of the day. For example, if you require your expert to be at the hearing of the matter, to listen to another expert's evidence in order to give you advice on that, those types of things will have to be specifically asked for and specifically argued, and will have to be specifically included in your final order. Same thing with witnesses. Witnesses will have to, if a necessary witness testified at trial, it's always better to include those witnesses specifically. And then the adjudicator's fee, Vaughan spoke about that as well. And the normal principles that the parties will be jointly and severally liable for the adjudicator's fee. If the adjudicator or the cost order follows the result of the matter, the adjudicator's fee will have to be specified in your cost order as well, to say that it's not jointly and severally anymore, the unsuccessful party will have to pay the adjudicator's fee if that is what the intention of the cost order is at the end of the day. So on a bit of a more practical note, when you are busy with the process or any litigation process, is to keep proper notes. Keep proper notes of all your attendances, not only with regards to the time spent on those attendances, but also the content thereof, especially when you're dealing with party and party costs, because some consultations or telephone calls could be regarded as not absolutely necessary. So you're going to have to show what you did, what you actually did, and why it was done, to see if it is an absolutely necessary party and party item, or if it can be regarded as overcautious or unnecessary, which will make it an attorney-client item. So please make proper notes of telephone calls, of consultations, of time. We get it a lot that people like just say we started at 9:30 and there's no end time, or attorneys, which they are entitled to do, will book out a day fee to their clients for work done that day because they are physically out of the office. But when you are considering a party and party bill, you will only be able to recover the actual time spent at the hearing, and the actual time that you were applying your legal mind. So now you've used the tariff, you've used the drafting of the bill, now you have your prepared bill. To get this bill of costs, as we said, your disbursement invoices will have to be attached to that, or your council's fees will have to be attached to your bill, and now you will be presenting this bill for what we call taxation or assessment of the bill. So the bills can be assessed or taxed in two ways. The High Court makes provision for taxation of bills of costs in two circumstances, which is one by virtue of a court order that orders cost, or secondly by agreement between the parties, which will be the case in an adjudication process. The parties agreed that there is cost to be paid. So you can either tax the bills in the High Court in front of the taxing master of the High Court, or you can appoint an independent tax consultant or assessor to tax your bill of cost. When you use the taxing master of the High Court, there's some pros and cons to that. Probably the biggest drawback of that is that the High Courts are very full and busy at the moment. So you could wait up to 6 or 8 months to get a chance to tax your bill of cost, which, as I understand from the adjudication process, is sort of counterproductive. The whole process is aimed at fast dispute resolution. So that is the drawback of taxing in front of the taxing master of the High Court. The good thing about taxing there is that you will have a taxed and allocated bill of costs, which you can issue a writ on immediately if you need to do so. And there are no fees payable to the taxing master of the High Court. There are certain prescribed taxation fees and drawing fees that are included in the tariffs, in the High Court tariffs, but that will apply whether you use an assessor or you use the taxing master of the High Court. The party presenting the bill will always be entitled to those drawing and taxation fees when a bill is presented for taxation. So the other option is to use an independent assessor for bills of costs. And then of course, if you're taxing in the High Court in front of a taxing master, there is an automatic right to review. There's a process that can be followed if you are dissatisfied with any of the decisions of the taxing master, or you feel that you have not or they have not exercised their discretion properly. There is a process of review of the decision of the taxing master, which will then be placed in front of the judge. to consider whether the taxing master's decision was right or not. When you're using a private assessor, obviously there will be a fee payable for them. The process will be much faster, of course, and the bills will be sorted out way faster than you will get it done in the High Court. But there will unfortunately be a fee payable to the assessment of the bill, which will also have to be agreed between the parties. Usually the fees of the assessor to the bill gets added to the allocator at the end of the day, but the parties will have to reach an agreement on which forum they want to use to tax their bills of cost and who's going to be responsible for the for payment of those fees. So and then of course when you're using an external assessor, there's no automatic right to review the decision of the assessor. That will also have to be agreed between the parties prior. Are we just going to accept the decisions as final, or will there be a provision that will have to be agreed between the parties for any aggrieved party by any decision for a right of recourse on that decision? The taxing master or the assessor will consider certain things when they are presented with a bill of cost. And that is firstly, that was the work actually done? And this is where notes become so important. You're going to have to prove that you actually did the work that you are asking a fee for. And if the work was actually done, that would also not necessarily mean that there is a party and party attendance. It might be regarded as unnecessary or not strictly necessary at that specific point in time. Then the taxing master will also have a look at whether the work done falls within the scope of the cost order that was given. Exactly now, as an attorney-client, was it absolutely necessary? Was this an overcautious attendance by the parties? Then they will also have a look at, now that they've established the work was actually done, it falls within the scope of the cost order that was made. They will have to assess a reasonable fee for the work that was done, and for this they will use the court tariffs as a guideline, or that is your baseline. They do have a discretion to slightly deviate from that when reasonableness requires them to do so. So the question will also be, is it fair and reasonable compensation for the work actually done that falls within the scope of the court order? Importantly here is that the assessor or the taxing master cannot read into the order, the cost order, anything that is not specifically in the cost order. And that is why it is so important to make sure that everything that needs a specific order is included in your cost order. They cannot decide on disputes between the parties. They have to follow the cost order as it reads. Unless the parties, of course, agree at taxation that certain costs can be included, that is not, provision is not made for. So it's very important that your cost order reflects the intention of the adjudicator or the parties as to specifically what you will be covered for and what not. Okay, so the procedure that you will follow if you wish to tax a bill of costs is to present your prepared bill with your disbursement vouchers. For example, in the High Court, the process will be that you draw a notice of intention to tax your bill of costs. You attach all your documents to that, and that will be served on the opposing party for consideration. Different divisions of the High Courts in South Africa at the moment have different guidelines as to how this is done. For example, in Gauteng, you will present your opposing party with a notice of taxation. They then have an opportunity to file a notice of opposition to that taxation. They've got 10 days to inspect your documents, further 10 days after that to file their notice of opposition. In this notice of opposition, they have to specify each and every item in your bill that they have a problem with and the reason why they are opposing that specific item. Now, usually at this juncture, it's quite easy to see whether the parties are going to be able to settle the bill or come to some sort of conclusion. Or if the bill is not opposed, that makes it easier as well. When a notice of opposition is received, the parties will then or apply for a taxation date at the High Court and then set your notice of taxation down for a certain date to be taxed by the taxing master of the court. When using an assessor, the process is a little bit more different. The parties will agree on that, and again, the process will be basically the same. The time limits can obviously be agreed between the parties as well. There'll also be a notice of opposition, and you'll appear then in front of your assessor to present arguments on whether on all the items that you feel are either unnecessary or should not be allowed on taxation. In the High Court, the taxing master will immediately after the taxation prepare an allocator, which is a document indicating the total of the bills, the amounts taxed off, including the drawing fees, including the taxation fees, and that will be stamped and endorsed by the taxing master, and that has the effect of a final order. You can immediately proceed upon request for payment and to issue a writ on such an allocator. When you are using the services of an independent assessor, the parties can also agree to have the assessor prepare an allocator, which will then can be submitted to the taxing master of the High Court, marked settled as between the parties, to get that endorsed by the taxing master. If this is not agreed between the parties and you have an assessment of your fees which is binding, that will unfortunately not have the same effect as an endorsed allocator, and you will probably have to issue summons to recover those costs that was decided on. Yeah, so that's basically the process. Just a few notes on council's fees. For example, if you're using council during your process and council has an invoice or rendered an invoice, that will be attached to your notice of taxation and your bill of costs. Now, council's fees are not prescribed by the High Court rules specifically. Every bar council in the country sort of had their own guidelines on what is acceptable in their division. The different courts in the country also has guidelines that they follow when they are assessing council's fees, and that differs quite significantly from division to division. The guidelines of the local bar association would be your guideline as to what a reasonable fee for council is, but again, the discretion of your assessor or your taxing master becomes quite relevant to assess whether council charged a reasonable fee. So you will not automatically be entitled to your whole disbursement on council's fees. That will be scrutinized. That is usually the biggest bone of contention in taxations in any case. That will be scrutinized. Certain divisions have certain time periods or time that council is supposed to be reading documents at 30 or 40 pages per hour, supposed to be drafting documents at 4 pages per hour, and they will look at the work that was necessarily done and then allocate a reasonable fee to council in respect thereof. And then just a note on VAT and taxations. If your client is a registered VAT vendor, you will not be able to include VAT on your, or recover VAT on your taxable of costs. This is was set down by an appeal court decision, PricewaterhouseMaynell and the Thoroughbred Breeders Association of South Africa. The basic easy way to explain this is that the client remains responsible for payment of his own attorney's fees, which he will then pay, and which will include VAT. If your client is a VAT vendor, he would obviously reclaim that portion of the VAT from SARS and then recover the cost, his costs or his out-of-pocket costs for legal fees from the opposing party. And because he has already or is able to claim his VAT portion back from SARS, he will not be able to recover the VAT portion from the opposing party as well. That would amount to a double compensation. So just a note on the rules of that if you're ever wondering why your VAT portion on April was disallowed, that is the reason for that. I think that is basically that with regards to costs. I don't know if there are any specific issues that anyone wants me to address them on. Vaughan, do you have anything else that you guys would like to get any input on? Tiffany?
Thanks so much, Serena. Just having a look. Okay, we've got somebody raising their hand. Okay, so I'm just going to allow you to talk. You can just unmute and ask your question.
Thanks. Hello, Serena. I'm a civil engineer and an adjudicator, so I've got very limited law background. Normally, in the adjudication board member agreement that we get signed before we start, before we even get the statement of claim from the first party, we state that for instance, the contractor initiating the adjudication, the contractor shall pay the full amount of the appointment fee and then the full amount of other invoices up to the last invoice, and then claim 50% back of the other party. That is on the fees on a 50-50 basis. But sometimes you feel like, you know, where the one party has a very good case that you want to make it a 80-20 for the fees. Can you change it then if you have it a 50-50 basis in your adjudication board agreement initially? Thanks.
Well, I think Vaughan would probably be better equipped to answer that question. You are talking about the adjudicator's fee. Am I correct?
That's correct. Yes, the adjudicator's
fee. I think Vaughan would probably be in a better position to answer that question because that's prior to a cost order being given. I do think that if there was an agreement to pay fees on whichever apportionment you did at the end of the day, if the adjudicator at the end of the day has the jurisdiction to make a cost order, they will be able to make a cost order in respect of the payment of their own fees as well, which I discussed that needs to be in your cost order, or at the end of the day, something needs to be specified like that. So, for example, the initial agreement was that the parties will pay the adjudicator's fees 50-50%, but at the end of the day, after hearing the evidence and considering all the facts, the adjudicator feels that party A should be paying party B's fees, and the adjudicator feels that party B should be responsible for payment of all the fees, which includes the adjudicator's fees. He can make an order to that regard.
Thanks. Thank you.
But if it can be done prior to, or when on the onset of the matter, before you've even received documents, I am not an expert in that field, exactly what the agreement between the parties will be prior to adjudication. Yeah, so I think Vaughan would probably be in a better position to answer you on that specific question.
Thanks, Serena.
Thanks, Serena. Katz, yes. It also comes down to the question of jurisdiction, and it's a very important consideration that I find that panels, as well as solar panel members, where there's a single member of a panel or adjudicators themselves, often overlook this element. So in as much as there is an agreement that the parties will be jointly and severally liable, that agreement is in respect of the adjudicator's fees. How I like to look at it is that entitles, that's again the threshold. So that entitles me as the adjudicator or panel member to be paid. And it also prescribes that there's a joint and several liability, or parties are paid pay the adjudicator's fees equally. It also enables you as the adjudicator to firstly then invoice a deposit for a deposit, which is very often the case. So it enables one to be placed in funds at the outset without considering a liability or responsibility on either party for payment of their fees. So in that respect, the agreement to pay then is that's what creates the contractual obligation and entitlement for the adjudicator to receive his remuneration or her payment. The question of the liability, in other words, which of the two parties should pay the costs inclusive of the adjudicator's costs, is a separate consideration. And it's important for an adjudicator, when faced with that, you would look at it. You need to determine whether you as the adjudicator has a right to make that assessment. In other words, there's a jurisdictional question. The jurisdictional fact that corresponds with that, or creates that jurisdiction is either in the contract itself, in other words, a specified right, specified obligation, specified provision stating that the adjudicator or panel has a right to assess and determine liability for costs. In the absence of that, as we saw in that Northern Development case, it looks to the whether or not there is an implied agreement. In other words, moving away from your initial consideration of the threshold jurisdiction, have the parties vested and expanded the adjudicator's jurisdiction? And if that has been the case and is the case, then you most definitely have a right, in my view, to enter into that consideration. I hope that answers the question.
Yes, thanks, Vaughan.
Okay, I see Stuart has raised his hand. Stuart, I'm allowing you to speak.
Thank you very much. Serena, morning. From personal problem that I've experienced when referring legal costs to the High Court for the taxing master, specifically when one of the parties is represented by a claims consultant, has generated all sorts of major problems where the taxing master has run into issues with not being able to tax it. He doesn't know what scales to tax it on, and it's created quite a few problems. What would your recommendation be in referring that sort of assessment or the taxing of costs to the High Court in that scenario?
Yes, the problem is that the High Court taxes into the High Court rules. They will apply the High Court tariffs, and the High Court tariffs is a tariff specifically designed for legal practitioners. Those are the attorney's fees. So when you are making use of an expert claims consultant, as you sometimes do, you will have to have some sort of baseline tariff that can be used for them. My recommendation would be that that those tariffs should be agreed on before. For example, if you are reaching an agreement prior to the adjudication process, that the adjudicator will be able to make a cost order. I think your agreement should include something to the extent of, I'm using an attorney and the tariffs will apply to him. I'm using a claims consultant and these are their tariffs. So that you will be presenting the taxing master with a taxation on an agreed fee, rather than them using the fee that they usually use in their courts. But that is definitely a big problem. The taxing masters in the High Court are used to taxing attorneys' fees. In circumstances like that, it will probably be best to use an independent assessor as well. The taxing master is a legal officer and they get their powers from the High Court rules. That is where they get their discretion from and their power to tax. So they will strictly apply the High Court rules, and the High Court tariffs cannot be applied to a person that is not a legal practitioner. Yeah, so you would probably have to get a set claims consultant fee list and agree on that prior to the adjudication process starting. That would be my feeling on the matter.
Thank you.
Thanks, Serena. If I may, Tiff, if I may just pop in there. Thanks, Stuart. It's an interesting predicament to be in, and I think, in fact, this discussion for me is quite interesting because, you know, the whole purpose of the adjudication process is for it to have been speedy, fast and nasty, and whatever, you know, all the sort of throwaway descriptions we've got of the process. But unfortunately, the reality is and has become that we are in that realm where we need to deal with these costs, because in a number of adjudications, and I don't think it's the prevalent or the majority of those, certainly from my point of view, that which I'm involved in, obviously, we are engaged in and incur legal costs, expert costs, etc., etc. So, you know, it's something that we tend to overlook when we sign the agreements. The agreements are generally geared, I think the rules are geared for the process to be speedy and effective. So I agree that if we do think there is a costs issue, that we deal with it up front, or there may be a cost issue, or there is an entitlement to determine costs. And that could be something which is dealt with at your pre-adjudication meeting before you've actually concluded your contract. The other question that this raises for me is when we don't deal with it in advance. In other words, we don't agree the tariffs, we don't agree the costs. If you, as a party to the adjudication, then ask for costs, and I've had this a number of times where attorneys have drafted the requests and the referrals, and they put their standard type particular of claim, relief, prayers for relief, further and alternative relief, costs of suit. It is also then an obligation on the parties to justify, explain, specify, detail the cost that they're asking for. So, you know, unlike in a high court litigation or badge court litigation, when I ask for costs, in my mind as an attorney in that process, I've got those tariffs in mind. Mm-hmm. So if we are pursuing costs in an adjudication, we have to actually include a section on costs. Not only then to say, this is why I believe I should be entitled to these costs, but this is what these costs are and why. And importantly, this is why these costs are fair and reasonable. There's also, you know, in the UK, there have been a couple of decisions dealing with costs. And one of them that is that I thought might be quite, you know, relative is a case called West Futures Limited versus Alan Wilson Construction. And that was a 2016 decision in the Technical Construction Court. And in that case, it was what had happened was that the claimant had been entirely successful, and the defendant's attorneys accepted an offer which predated the adjudication in respect of payments. The claimant agreed that this acceptance gave rise then to a compromise between the parties, and there was a dispute as to what the costs were covered by the agreement. So there was an agreement to then pay and an offer to, but what were the costs that were claimable? And the court ruled that the claimant was entitled to the costs of court proceedings to which reference had been made in the offer, but decided that the costs of the adjudication were not costs of the proceedings and so were not recoverable. So in the enforcement process in that instance, there was an attempt to recover costs in the adjudication, which was unsuccessful, which just highlights for me the importance that there is to establish your case through your referral if you're looking for costs. The judge considered the claimant's argument that the words in the settlement agreement, all the claimant's legal costs incurred in this case, included costs in the adjudication. Judge ruled, however, that in the context of the offer, that was reference to court proceedings than adjudication. So I'm just referencing that case, less about the type of cost you can claim, but the importance of actually claiming those. And whether we do that via an agreement in advance, via the pre-adjudication process, if you enter into it, or in the notice of dispute, or in the referrals themselves, it's something which has to be dealt with specifically.
Thanks, Vaughan. Mike, I see you have your hand up. I'm allowing you to speak.
Hi. Yes. How do you determine costs where the adjudication rules prevent the parties from being represented by legal counsel?
Well,
Serena, if you...
Yeah.
Thank you. No, if
Yeah.
you go ahead,
I don't think you will be able to, unless, again, as we just said, there is an agreement between the parties to some sort of extent to what costs they can recover prior to the adjudication process, but that would be something completely different than the normal run of a cost order. As explained, yeah, the cost order is for legal costs. When a client performs work himself, even in normal litigation processes, he won't be able to recover his own work done. He's only able to recover his legal fees or that which he is out of pocket for legal fees. So, for example, even in normal litigation, when a client gets documents and sorts through them and extracts the most important stuff, he won't be able to charge a fee for that. So I think probably, again, you'll have to look at pre your adjudication process to come to some sort of agreement that there is no legal representation in this matter, but we will be able to recover, for example, expenses that was incurred for experts, etc., those types of things you can still agree on to be included in your cost order. Does that help at all?
Yeah, it's just that some rules prevent the parties from being represented by practicing legal attorneys or counsel. And they're not specific about each party carrying their own costs. So and it becomes even more difficult when one party does not participate at all in the adjudication. And the party who has made the referral in the prayer prays for all costs and throws in the kitchen sink, the kitchen and everything else. And it is very difficult to determine what costs should be allowed, what costs shouldn't be allowed, and because there's no rebuttal from the other side as to what costs are appropriate and what costs are not appropriate. Yeah, and it is a problem with adjudication, I would say, particularly in South Africa, where there are no statutory regulation that governs adjudication. It's a sort of contractual agreement.
Mike, if I might just come in, and I think that's when the whole concept of costs, as I say, has become something which I don't believe initially was costs in adjudication, was something intended. And if you look at how the Housing Grants Act, by example, has sort of migrated towards this consideration, it shows that I think that adjudication is perhaps not exactly what it started out to be in all instances. My view is that on this would be as follows. If the adjudicator is presented with that argument, in other words, more than just costs of suit, and there's an argument where the adjudicator is presented by the referring party with a section in the referral dealing with costs and saying, this is what it has done, there's a line that one has to draw in the sand between the cost that you would incur and whether there's a damages claim, because sometimes people look at this cost entitlement as a waste of my time and therefore I'm entitled to something in consideration therefore, etc., etc. Bear in mind that I entered into this process by agreement and therefore I accepted some responsibility to deal with the process. So in that instance, then my own costs, as Serena points out, are going to, in all probability, be excluded from a consideration. However, if in my representation to you as the adjudicator, I argue for costs of an expert forensic planner, for example, or costs of a PQRS to determine my quantification or sustain my quantification of the claims. I think that provided those costs are dealt with and are argued and are properly extrapolated, if the other party doesn't reply to it, it doesn't mean that they've accepted it. If the other party doesn't reply in detail to it, if the other party simply ignores that request, I still think that you as the adjudicator would then have a responsibility to deal with it. And how would you do that? I would deal with it in the normal course, where I would be saying, respondent, please answer these allegations specifically and tell me the following. And you can interrogate the costs that they've put forward, that the referring party put forward. So I think that then would give you the jurisdiction. And the fact that they're asking for it, that would give you the jurisdiction. And your jurisdiction as an adjudicator would be to determine what would be fair and reasonable, given the fact that there's an agreed participation in a process. And I have in instances gone further where I've actually dealt with those costs and what I think those costs would be reasonable. I've had instances where parties have submitted timesheets of the forensic planners, and I've looked at those and I thought, it's not always possible to work 30 hours out of 24, So there's an interrogation and there's an inquisitorial process. If legal representation is excluded, I don't think that excludes one from asking for costs. But there would be very specific classes of costs that you would be entitled to look for, firstly. And I think the overriding factor for me would be A, what's fair and reasonable, and B, in consideration of the fact that I participate in this process willingly, knowingly, and more importantly, from a cost point of view, knowing that I'm going to incur costs. Then I guess one of the other debates is whether or not I go into that process and I then, although I'm not entitled to representation at a hearing, I use the claims consultant to tighten up my submission. And I think that would be part of the consideration. In what circumstances did you do that? Is that something which the adjudication process envisages? I think that these would be questions that you as adjudicator would deal with. My feeling on the costs is that just as you detail your other reasons, unpack your award on costs. I've put in schedules of what I think the cost should be. And then the overriding thing for me with these costs is that if you are going to have that fight as participants in an adjudication, as we've said before, agree that up front. Agree up front, and I do this in arbitrations, that any costs would then be disputed or dealt with by an independent assessor instead of going to the taxing master. We have that by agreement. We agree that that independent assessor will produce a locator, and we will then have a liquidated amount of costs. So those are things that need to be dealt with up front. Thank you.
Yeah, it's quite complicated though when you when you have a defaulting party that just doesn't participate, and you know, you have rules that state that the parties can agree to be represented by legal counsel, but they need to agree to it beforehand. So with one party being silent, what is the inference? That they have consented, that they have not consented? It becomes quite complicated, or it can become quite complicated, and you end up as the adjudicator making a lot of assumptions, which is really not good. The more assumptions you make, the more likely you are to be challenged.
Mark, I think that this topic that you've raised here, this, you know, the absent responding party, I think is you know, could even be subject matter of a workshop later on in the year, because I'm not coming against, or I'm not coming up against it regularly, but it is certainly a topic that I'm getting across my desk quite consistently. Now, if one looks at that, and I mean, I'm suggesting this, I'm not positing this as an absolute way of dealing with it, but if one has that situation, provided you have an agreement to adjudicate that you have in your contract, let's risk assumption and say that that is in place first. Second, that agreement is clear and that the parties would participate and have agreed to the process. There's a process in place for either agreeing an adjudicator or, if not, appointing. We go through the party is notified and the party does nothing, doesn't reply to the notice, doesn't attend, doesn't participate, but has a contractual obligation to participate. Doesn't agree an adjudicator. There's a default position where you approach a nominating body. The nominating body appoints an adjudicator. Now, once that adjudicator is appointed, that adjudicator then can proceed, but he proceeds under risk, not of his fees being paid, because the referring party would then be liable to pay those fees. The adjudicator then proceeds under risk, and it's less the adjudicator's risk and more the referring party's risk, that at the end of the day, the award that's given may not be enforceable, because the party may not be participating because he contests jurisdiction. So that's always the risk. And I say to people, if we're getting into that space, you've got to get into that space with open eyes. Now, if you take the NEC contract without an adjudication, I can't go to arbitration. So I will go through that process irrespective of him participating or not, because without that process, I can't get into the arbitration. So yeah, I agree with you totally. I think it's a potentially a topic that we can spend a bit more time on. But as a general point, that's generally as I've been seeing it being dealt with. Thank you.
Thanks.
Thanks everyone. Yeah, I don't see any more raised hands. So, and I'm just checking the Q&A box. There's just a comment in there. So yeah, thank you so much, Serena, and thank you, Vaughan, as well. Thank you for everyone who's attending on that side. And yeah, I hope you guys enjoy our monthly sessions that we have.
Thank you. Thanks, Tiff. Thank you, everyone, for organizing. Serena, thank you for participating. The challenging world of costs and recovering those. And then just lastly, again, I want to please invite anybody, any of the attendees or people, you know, with any interest in, please let us have your comments, let us have your suggestions on topics, or any questions on costs that we've discussed today. We're always open for that discussion, and we want to try to make these presentations relevant not only to those interested in adjudication generally, but also to the practice of adjudication, bearing in mind that our commitment as CAASA is to advance adjudication as a system for resolving construction disputes. Thank you, everyone, and thanks again, Tiffany. Norman, thank you.
Thanks, Vaughan. Okay. Have a good day, everyone.
Goodbye. Thank you.